Here we are. Okay, welcome everybody to the last event of 2021. This VSG has been hosting events virtually since the pandemic, and we've been fortunate to just have so many experts and specialists come and do talks to support the startup communities, people who are interested in entrepreneurship, technology innovators, or just students and faculty who aren't exactly sure what they want to do with their research or what after they graduate and are interested in all of the different avenues. And today, our last speaker is actually a very unique one because we usually only have our legal clinics as an internal resource for the teams that actually incubate with us. But fortunately, we are hosting an open legal clinic for all of you out there, and we have Dustin from Roca. He's been to the garage before. He's done an Oceanside chat for our teams. Every single time he comes in, it's such a great resource and experience for the teams. I won't introduce you at length. I'll let you do that yourself, Dustin, but I just wanted to say thank you so much once again for coming in and being such a great support of VSG and what we do. And thanks for closing out our year. I'm really looking forward to your talk. Passing the mic now.
Well, thank you, Arcelia. I'm very happy to be here. Just a quick background here about myself. Like she said, I'm a partner at Roca. I'm in our IP group. I do a lot of IP in terms of patent prosecution and litigation, trademark preparation and enforcement, and I do licensing work as well, and trademark and branding. I'm a former aerospace engineer. I got my degree from USC Viterbi in 2004, and then I went to work at Northrop Grumman, and then later worked for a Boeing subcontractor on the 787. And so my talk today, we're going to mostly focus on what kind of contract provisions you need to protect your IP. I'm going to start here with an overview of the various forms of IP, just so we're all on the same page. And then it's really important to note that the contract provisions that you have are going to vary depending on the type of IP you want to protect. So the contract language you need to protect patents is different from that if you're protecting copyrights. So it's clear, it's going to be really important to keep that straight in your mind, what kind of IP you're protecting. So the 5 main sources of IP are patents, copyrights, trade secrets, trademarks, and trade dress, which is really a form of trademarks. So I'm going to go into now a little bit of background on what each of those is so we can keep them clear in our mind as we go forward. In terms of patents, there are 3 different types. There's a utility patent. This is probably the most valuable form of patent protection. It covers the functional aspects of your product. So it can be software code, covering the function, how that software functions. If it's a widget, it could be the structure of that widget and all the components of it. Or here, as I've demonstrated, an aircraft engine and how the various subsystems function. Another type of patent is a design patent. That covers just the way your invention looks. It doesn't cover anything about the function. It's also important to note this can cover a GUI of your software. So if you want to protect the GUI, just the way it looks, the look and feel of your software, you can protect that through a design patent. So with these 2 forms of patents, you get the function plus the way it looks. You cover those separately. I typically advise that you do both so that someone can't copy either the function or the appearance, right? Both can be really important in the marketplace to differentiate yourself. And the third one I note here, it doesn't come up all that often, is a plant patent. These are important for like nurseries. And some people, as as the cannabis space grows, this might be important for those industries. But typically what we do is in the nurseries that are breeding flower varieties, you can protect those with a plant patent. All right, trade secrets is another form of IP protection. This is an alternative to patent protection. So one of the requirements for getting a patent is that you disclose your invention to the public. You have to give all the details, how to make, use your invention. But if you don't want to do that, if you don't want to disclose it to the public as part of that trade-off, patent protection for disclosure to the public, your alternative is to keep everything secret with trade secret laws. This can be really important for things that are not patentable. So formulas by themselves are not patentable. Equations by themselves are not patentable. as part of a larger system, they can be, but in and of themselves, they're not patentable, right? So for instance, Coke's formula by itself would not be patentable, but it's very valuable, obviously, to the company. So they keep that as a trade secret. And the good thing there is it can go on indefinitely, right? Coke's had their formula for decades now, and it can go on indefinitely. Whereas a patent only lasts 20 years, you can keep a trade secret indefinitely. So this is a great form, particularly if it's unpatentable subject matter or something that's not patentable. So a formula or an algorithm. The downsides, though, are that someone can reverse engineer your product and can figure out your trade secrets. So you don't have any cause of action against them. So it's not illegal for someone to take apart your product once you've sold it in the marketplace and for them to try and reverse engineer it, right? They might violate some warranty or contract provision that you've associated with the product, but it's not going to be illegal for them to do so. So that's the risk if you go this route and want to keep things as a trade secret. All right, so going on to trademarks. Trademarks really just identify the source of your product. So they don't identify the product itself, they identify the source. So you know that, hey, any product that comes branded with this certain name, I know where that comes from. I know it comes from this one company. I know it comes from a particular source. And therefore, consumers can rely upon that identification to know the quality of the goods and services they're getting. They say, oh, I know anything branded with company A, I know what quality I'm getting. Maybe it's a cheap disposable product, or maybe it's a really high quality good, right? And they've come to associate that brand with a particular level of service. So trademarks just function to identify the unique source of goods. You can file a trademark application based on actually using it. So once you start using that mark in connection with your services or your products, you can file an application. Or you can file an application saying, I have a genuine intent to use this in the future. Here's my mark, here are my goods, I'm going to start using this in the future. You can file a trademark application before you even begun using it. Now, I go over some requirements here. I'm not going to go into too much detail because this is just an overview, but your mark has to not be confusingly similar with someone else's mark. So the words have to be different enough and the goods and services have to be different enough not to cause confusion with someone else's brand. So that's the overriding concern of trademark laws, is to protect consumers so that consumers are not confused between two brands. So if you put them side by side on the shelf in the marketplace, a consumer would not be confused buying one thinking they were buying a product from another company. And there are a lot of factors that go into it. It's sort of a complicated analysis. This is something you want to consider when you are branding, though, is doing a search, seeing what else is out there, and then sort of running through this analysis with your attorney to make sure that your brand is distinct enough. And here, I just give a few examples here. Again, not going to go into a lot of detail, but there's a spectrum of trademark rights. The further you are along on the right here, the more protection you get. And the closer to the left, either you get less protection or no protection at all. So you want to be on the side of making up a word like Exxon or Adidas, just make up something, or arbitrary, a word that exists but has no meaning in connection with the goods and services. So Apple's an example of that, right? Apple has no real connection to the consumer electronic products, right? So that's an arbitrary use of, it is an English word, but it's an arbitrary application to their goods and services. So you want to be on that end of the spectrum, sort of the green yellow here, right? That's where you want to be when you pick a mark. And then when you get down into like suggestive, that means there's some connection. You can sort of piece it together. Consumers can sort of figure out, okay, Netflix, you can figure out what their products are, but it takes a little bit of mental hoops. Descriptive, you really don't want to be in this field. This doesn't require any mental gymnastics to figure out what their products are. American Airlines, Burger King, it's right there in the name. You know what their products are. These are harder to get protection for. Now, certainly they've done so, and I think their logos become really important because that helps distinguish them in the marketplace. So if you're down here on the descriptive side, you might not be able to get a trademark registration until you've used your mark for at least 5 years. So that's one of the requirements. The trademark office will say, look, we think your mark is descriptive, use it in the marketplace for a long time, then we'll be convinced that you've actually, consumers will identify you as being a single source, right? So when Burger King first came out, consumers might not realize there is a single Burger King, right? They might just think that's, sort of a generic description. But once they've been used in the marketplace for a long time, consumers will then come to identify that as a single source of hamburgers. And then generic, these are things that are unregisterable. There's no way you can register if it's a generic term. So grocery store would be unregisterable. So you want to try to slide to the right on the scale. All right, now going into copyrights, the statute actually lists out the types of works that are eligible. So it's things that you would expect: literary works, books, musical compositions, graphics, computer programs. This is very important. I think probably for a lot of you, computer programs are eligible for copyright protection. So you can actually submit your code to the Copyright Office and get a registration for that. Sound recordings, architectural works, other things. But this is an exhaustive list. This is what the statute says is eligible for copyright protection. Okay, now I'm going to start going into really the meat of the presentation today about how do you protect ownership of IP. And this is just an overview of the ownership for the various forms of IP. So in terms of patents, it's presumed that the inventor is the owner. And the inventor is anyone who contributes to the conception of an idea. So not the person who actually builds the thing, but the person who comes up with the idea. I want a software program that does X, Y, and Z. I came up with that idea. The person who codes it might not necessarily be an inventor if they're just sort of implementing my idea. The same thing, it would work in the hardware space. Hey, I want a transistor that does X, Y, and Z. Again, if someone's just using sort of routine skill in that industry to build what I came up with, they're not the inventor. It's the person who came up with the idea. And so the thing to remember here is that the inventor, they're presumed to be the initial owner. So you're going to need, as we'll discuss later, you're going to need something in your contracts to assign those patent rights back to your company. Copyrights is next. Copyrights is probably the trickiest in terms of the legal framework. It depends on whether the individual creating the copyrighted work is an employee or an independent contractor. If they're an employee, it's easy. The company is the original owner of that copyrighted work. And we'll go into how you distinguish between employees and independent contractors later. But if they're an employee, you are the original owner. Your company is the original owner of that copyrighted work. You don't need a separate assignment. You might want to get one just to kind of button it up and be safe, but you're the original owner. Independent contractors, the author is going to be the owner unless they fall into this work for hire exception, which is very narrow. So in almost all situations, if you have an independent contractor creating something for you, they are going to be the owner and you're going to need to get an assignment back to you. So it's very important. And that's why I suggest in both cases, it's best just to have them sign the assignment anyway, just to be safe. But it's important to notice there is a very significant distinction between employees and independent contractors when it comes to ownership of copyrights. Now going on to trade secrets. Trade secrets, your company's going to own them, so you don't have to worry about that as long as you take reasonable measures to protect the trade secret. And there's no bright line rule for what constitutes a reasonable measure. It really depends upon the nature of the secret and how important it is to your company. So the more valuable it is, the more protection the court expects you to take, right? And so there are cases where defense contractors had very important secrets and they didn't tint their windows, and someone was able to look in through their windows. And the court said, look, you're talking about billion-dollar secrets and you're talking about window film that's hundreds, maybe thousands of dollars. You didn't take reasonable commercial measures to protect your secrets. They sort of had everything else buttoned up. They had security guards and they had access cards and all that sort of, but they didn't tint the windows and someone could just walk down the sidewalk. And the court said, look, that's not taking reasonable measures if these secrets really are so valuable to your company. And actually about 10%, when cases go to litigation, about 10% of trade secrets are found actually not to be trade secrets because they didn't take reasonable precautions. And so what I suggest is if you think you have trade secrets, if you said, okay, look, I'm not going to go the patent route for this certain thing, I'm going to keep that a trade secret. Make sure you're very clear on what exactly is that trade secret and how you're protecting it. Make sure all your employees know it's a trade secret. Make sure that they've identified. So identifying it precisely is really important. A lot of people sort of get into the situation where they don't want to claim it's a trade secret until it's a problem. Ex-employee, he's gone off and taken this information. It might be too late at that point. right? So identify the trade secrets up front, put the right precautions in place to protect the trade secrets. But in terms of ownership, you don't have to worry about any assignment or anything like that in terms of trade secrets, as long as the company is taking, like I said, reasonable measures to protect it. Trademarks, these are owned by the company because as long as you're controlling the nature and the quality of the goods and services that you put out, you're going to own the trademark, right? So you produce a widget, as long as you control the quality of that widget that goes out the door, or you control the quality of the software product, you are responsible for maintenance of that product, you're going to own the trademark. So you're not going to have employees assigning any rights and trademarks back to the company. But we'll go over some potential pitfalls later about how you can lose trademark rights if you're not careful. So, but in the initial instance, ownership of trademark is going to be in the company, as long as you're, controlling use of the mark and controlling use of the quality of the goods and services that your company produces.
Quick mini interruption, Dustin.
Please.
I didn't question what kind of format you like for Q&A.
Sure.
Do you have a question in the chat? Would you prefer to wait until the end of
no, please go ahead. Yeah.
Okay. Anand, are you comfortable asking your question out loud? I love it when people actually, I can always ask it for you, but please.
No. So thank you for taking the time. I have had independent contractors at some point in my company work on small pieces of code and whatnot. I've always had them sign this work for hire contract. So one is, does that put me in a better position, right? And then second, what about internationally? I've had a contractor internationally. I draft up the work for hire contract in California. I have a conversation with them and whatnot, and then they sign it and whatnot. So would love your thoughts on that.
Yeah, that's great. Yeah, and I'll get into some of those details. So, the question is whether their work actually qualifies for a work for hire. Maybe it's best if I advance the slides here and I can show you, and then I'll go out of order here.
That's the trick. That's the tricky part about questions.
No, it's okay. No, it's very interesting. So, so I'll give you the short answer, and then we can kind of go through it. So, it's unlikely that they actually are creating a work for hire, because work for hires are limited to this list here. So only certain types of work can be works for hire, but they can assign their rights to you, right? So you're better off actually having them just sign an assignment from them to you and saying, people typically have language that, oh, we agree this is a work for hire, but it might not be. And there's usually a catch-all that says, well, and if it's not, then you assign it to me, right? So here's the problem with work for hire, right? If they're an employee, easy. Anything they do is a work for hire. Your company owns it initially. If they're an independent contractor, it's only a work for hire if it's one of these 8 things here. If it's a contribution to a collective work, a motion picture, a translation, a supplementary work, compilation, text, test, answer, or an atlas. It's a very old, strange list of things, but only these things can be works for hire. And there has to be an agreement in writing that's a work for hire, right? So you see how narrow this is, but it's okay, right? It's okay that it's not necessarily a work for hire. They can still assign it to you. Your company wouldn't be what we call the initial owner, right? So it wouldn't be owned by the company, but it would be owned by you the second that it's assigned to you. So the safer route is just to say, look, to the extent it's a work for hire, we agree that it is. If it's not, then you hereby assign all your rights and that copyright back to the company.
That can be at the beginning of the working, like, hey, here's the work for hire contract, and in it, whatever you do for us, will fall, and you assign it to us, basically.
Exactly, and that's the safer thing, really, is to not lean so much on the work for hire, but just to require them to assign it. That's right.
Got it. Thank you.
And then your second question in terms of international, there are, it's okay if it's just like software code. It's not going to be an issue for you. There are some other rights that are sort of recognized, but more it's in like the artistic space. So in terms of like ownership of like sculptures or paintings. There are certain moral rights or attribution rights that might be required internationally. It's going to depend on the country. But if you're just worried about like code, you're going to be okay.
Yeah, it's just code that we hired, and they wrote small pieces of it. So
that's fine. Yeah, that's fine. It only gets sort of dicey when you really get into the more artistic stuff. Other countries will say, even if you assign it, there are certain rights that preserve within the artist. So, but not really relevant for tech companies.
Thank you.
Sure. Okay, so now I'm going to jump into some of the sort of more the meat of contract clauses. One of the first things you look for is when you have an employment agreement or an independent contractor agreement, you want to define intellectual property very broadly, because you're going to assign it to the company. You're going to say, hey, look, all intellectual properties, you agree to assign it back to the company. And I just gave you an example here. I think we can probably circulate this PowerPoint later so you can use some of this language and compare it against your own. But I wanted to give you a sense for how broadly we think about intellectual property. It's really important if you're using one agreement for various roles. So if you're going to have your marketing people sign the same agreement that your coders sign and the same agreement that your engineers sign, they're developing different forms of IP, right? Your marketing people are going to be developing text and maybe graphics, maybe videos. The forms of IP they develop very different from your coders, right? So you want to have a very broad definition if you're going to use the same agreement. And so something like this talks about all concepts, all invention, all trademarks, names, likenesses, whether it exists now or in the future, computer architecture, scripts, designs, processes, even methods of doing business, right? Have a very comprehensive definition of IP. We call this, it's sort of overkill, but we're really trying to make sure we don't miss anything in this definition of IP. The second thing really to include is look for an improvement or derivative works clause. So you want to say, look, not only everything that you invent is going to be assigned back to us, but also if you make any enhancements, improvements, and changes to our existing IP, right? So someone might not be making something out of whole cloth when they come in. They might just be modifying existing IP, right? Existing architecture, existing code. You want to make sure that you're assigning that as well. So I typically call that out separately and say you're also assigning not just the IP that you invent, but also improvements. And derivative works is a term relevant for when you modify a copyrighted work. Make sure there's a clause here that covers these enhancements, modifications, redesigns, developments. Again, very broadly. So it doesn't have to be, we say it's improvement, really it's any redesign, any change to it. They have to assign that to the company as well. All right, okay. So this is probably the most important slide. So I wanted to flag it for you. There are 3 words and they're very important and they don't stand out, and so you might miss it. So when you have an employee or an independent contractor assign something to you, you want the language to say they agree to assign and does hereby assign. The does hereby assign is actually critically important. If you just say the employee agrees to assign all IP rights to the company, that's not sufficient. I know it's kind of counterintuitive, but employee contractor agrees to assign all rights is not enough. It has to say agrees to assign and does hereby assign. So this sort of present tense, does hereby assign. Courts have actually addressed this. There was an employee at HP, at Hewlett Packard. He had signed an employment agreement that just said agrees to assign his inventions to the company. Didn't say he does hereby assign, just says agrees to assign. And then he basically invented something, left the company, patented his inventions, and then sued people for infringing his. And HP said, well, you can't sue us. You actually agreed to assign it. We own that patent. And the court said, no, you said you agreed to assign. That's some future act with no date on it. So an agreement to assign in the future, the court said, is not an agreement to assign it now. It's some uncertain date in the future. And so it's not sufficient to say, I agree to assign. So this really bit, and that, HP, obviously a big company, you think they'd have everything buttoned up, but this came back to bite them. So I hereby assign, like I specify here, it's a present assignment of current and future, but an agreement to assign is something indefinite. It's an agreement to do it in the future, but you can't hold them to a date certain, and therefore it's not enough. So if you take anything away, it's really these three magic words: does hereby assign. Critically important.
Can I ask a question on this?
Sure.
It's interesting you're raising this because I've pulled up my contract and basically it says contractor hereby assigns and licenses, right? So you're saying agrees to assign and does hereby doesn't work. It needs to have the does hereby.
Yeah, if it's just agrees to assign. If it says hereby assigns, you're okay.
Yeah.
Yeah.
Okay.
Yeah.
So
you're okay.
it's the agrees to is the part which you're saying. Basically.
Exactly. Yeah, exactly.
Interesting.
Sort of it's the future tense versus the present tense.
Thank you.
Yeah, exactly. And it's not something that any of us would have predicted before this HP case came up. It's
Crazy.
not something that any IP attorneys really saw coming.
This is why you need a good attorney.
Yeah, right, exactly. And yeah, even HP didn't see that one coming. So, and really the way it develops, right, it's that guy's attorney made that argument before the court and said, well, what arguments do we have that we own this IP? Well, it says I agree to assign. It didn't say I assigned it. I just agreed to. Maybe I'll do it in the future. Maybe I'll do it in 30 years. And that honestly, and that's ultimately what the court picked up on and said, there's not definite enough language there to actually be an assignment. And the second point is just as important, that even if you have all this language, does hereby assign or hereby assigns, it's important to follow up with an assignment. So if you're filing a patent application, we file an assignment when we file that patent application. So it's sort of a belt and suspenders type approach. The employment agreement obligates them to assign it and does in fact assign to your company, but also filing that assignment with the patent office is a way to sort of make sure it's all buttoned up. And then that assignment gets recorded to the patent office's database. Then you can be certain that you own everything. So include language in your employment agreement that obligates your employees to sign those papers, right? So not just, okay, here's an assignment you're obligated to assign. Also, you're obligated to follow up any papers that my attorney sends you. You're obligated to sign those assignments as well. We say execute all rightful other papers and generally do everything which the company finds important to protect and maintain their IP. Right? So put that obligation in there as well. Then there'll be no dispute, right? You really don't want to get into a dispute later on where you're arguing about whether or not the employment agreement or the independent contractor agreement did assign it. If they followed up with an assignment, it's clear as day, right? So sort of that two-pronged approach is the way to go. Okay, now going back to copyrights. So I mentioned here, it's the author who initially owns it, right? And so you do have to be careful. If you don't fall into one of those exceptions, it's the author who owns it. And so what you want to do here is define copyrights very broadly, again, in your employment or independent contractor agreement. Here's an example. Again, you can probably take this if we circulate this later, an example, but you want it to be very broad: graphics, photos, videos, logos, marketing materials. Cover everything that you can think of. And tailor this to what your company is actually doing, but have a very broad definition of what copyrighted materials are. And then again, use that same language about agrees to assign and does hereby assign to the company all copyrighted materials. So that's going to protect you. And then, okay, now we're getting back into the work for hire exception that we touched on earlier. So this is one of those very interesting things. It's really sort of a relic of the law not being updated in a long time. So again, like I said, the author is the owner unless it's a work for hire, right? So if they're an employee, to work for hire, no problem. And the real distinction there is just who owns it initially. Is it the author and then they have to assign it to you, or are the rights initially invested in the company from the start? And so it's a subtle distinction, but there are some important, significant distinctions between those two. So one is, with like Superman, right? Superman, the character that was created, it was vested in the author, and then they assigned their rights. I don't know, someone could probably correct me if it's Marvel or DC, whoever owns Superman, right? But there is a provision in the Copyright Act that says if you assign your rights to another company, you can actually recall your rights after a certain period of time, right? So this happened with a lot of famous characters, right? Basically, it's the Stan Lee, right? He assigns his things for pennies on the dollar because he didn't know they were valuable initially. Then you go down 20 years later, hey, these things are all of a sudden worth billions of dollars, the Marvel franchises, all of that, right? So it does allow, if you're assigning your rights, you can actually, it's a reversionary interest that we call it. And it can come back to the original owner, and then you renegotiate that contract. But if it's a work for hire, that's not available. So that's one area in which the distinction is really important. If Stan Lee had been an employee and the rights had initially invested in the company he worked for, there's no reversion. But if he's this independent contractor assigning it, he can revert back and then renegotiate.
Dustin, there was a question by someone who had to jump for a meeting, but I think it would probably fall within this slide.
Okay.
Jayron was asking whether a collaborator at a university, not the inventor of the idea, but somebody who collaborated with them in some way, whether they fall within this work for hire style, space of safety and security, or like, and I this is probably a very relevant question to a lot of teams whose technology is born out of research at a university.
Yeah. So is your collaborator in the university considered to be a work for hire? So is this like undergrads working together, or I'm trying to understand the hypothetical exactly.
I know. I wish she was still here to ask. So the word collaborator is really kind of the sticky wicket. So I'm not exactly sure what it means by collaborator, but I don't know. Is there a way to answer this without her here to clarify?
Sure. Yeah. I mean, there's a lot potentially that you have to worry about in that space, right? So the university, first you have to worry about the university. If there's an agreement with the university that talks about IP ownership, right? So that's kind of your first line. If you're a grad student, you may be subject to some obligations, maybe a royalty-free license to the university. A lot of universities will do that. They'll say you can own the IP, but you have to license it to the university, such that you can't turn around and sue the university for infringement, right? You own your IP, but we have a $0 royalty to use your work. So check that first, see if there are any obligations or any restrictions on ownership with your university. But they didn't help with the idea, she said. So, it's in copyright, it's whoever creates the work, right? So really patents is where you're thinking about the conception of an idea, right? So if you're in the patent space and someone helps you, but not with the idea, but just what we call the reduction to practice, building the thing, right? They're not an inventor, so you don't have to worry about that, right? So, but if you're in the copyright space, it's whoever creates the work. So it's different, right? Patents, you're thinking about conception of idea. Copyright, you're thinking about who actually puts pen to paper, right, so to speak, or keystroke to computer, right? Who's actually doing the work. They're going to be an author, and so it's going to depend. It's going to depend on what kind of IP. That's why it's so important to figure out what kind of IP you're concerned with, because the rules vary, right? So you got to be very clear. Hey, are we talking about copyrights? We're talking about patents, and like I said here, it's very unlikely to work for hire, right? It's got to be one of these things. It's got to be one of these. One of these 8 or 9 things, and it's unlikely that the work you're creating is one of those things.
Thank you.
Sure. Yeah. So that's really the rub with work for hire. It sounds like a kind of a nice way to say, hey, look, we own it. We don't have to deal with assignments. It's just ours upon creation. That's true if they're an employee. If they're not, then it has to be one of these types and an agreement in writing. So this is a twofold requirement. It's got to be one of these things plus an agreement in writing that it's a work for hire. Right? People usually get this last part right. They'll agree in writing that it's a work for hire. You see, you put it in your employment agreement. Hey, anything you create for us is a work for hire. Yeah, but it's not one of these things, so it doesn't qualify. So I'm going to go on to the next slide. So how do you distinguish between employee and independent contractor, right? That might be your first question. I don't even know if this person is an employee or an independent contractor. They work for me part-time. I control some of their thing. How do you draw the line? Well, the court has fleshed out there are basically 3 things that you consider. So the first is how much control does the employer have over the work that is done? So if you really get to control their schedule, you say, hey, you need to do X, Y, and Z for me. You need to come into my office. I give you a laptop to do the work, or I give you money to buy a laptop to do the work. Okay, that's a lot of control over the production of the work. But if you don't, right, if they're sort of working on their own schedule, their own timeline, or working remotely like most of us are now, they're using their own home computer, that's going to make it look more like they're an independent contractor. So that's sort of like control over the work and the schedule that the work is done on. And also the next factor is how much control do you have over that potential employee, right? So can you tell them, hey, I want you to work 9 to 5, Monday through Friday? Or is it, just, as soon as possible when you can get to it? Can you give them new assignments? Can you say, hey, add on this other thing? And that would be expected as part of their job duties. Determine the method of payment, and then if you have the right to hire that employee's assistance, right? So the more it looks like the typical corporate 9 to 5 here, the more likely they're going to be an employee. And the third factor is status and conduct of employer, right? So if the potential employee is producing works that your company typically produces, so if you're a software company and you're hiring someone to produce software, that looks more like an employee because that's the business you're incorporated to do, right? If you're a software company and you hire someone to do a sculpture outside your building, that's not really your line of business, right? That's not the thing that you do regularly. That's going to look more like an independent contractor. You hire someone to come in, produce artwork for your building. Again, you're not in the business of artwork. Maybe you're not really controlling their schedule. You're not providing paintbrushes and all that stuff, right? And the paint. So they're going to look more like an independent contractor. And these last two are probably the most important thing. Do you provide that employee with benefits, and do you do tax withholdings? So, if they're W-2'd, it's very clear, right? You're doing tax withholdings, you're giving them 401k benefits, leave benefits, all those sorts of things. In that case, almost certainly they're going to be an employee. If you don't provide those things, which I think probably a lot of people don't when they're contracting out work in the software space, right? You might hire a coder, they might be in a different country. They're going to look a lot more like an independent contractor. But here are some factors. Again, no bright line rule. The court sort of balances all of these things when they're trying to figure out whether someone is an employee or an independent contractor. But the takeaway is, don't rely upon work for hire, right? You can see how this gets kind of muddied. You might say, well, we've got 2 of the 3 factors. I don't know where this person falls. It's a close call. Well, don't rely on work for hire. Just get the assignment, have them assign their rights. Don't rely upon any clause saying that it's a work for hire and that you own it initially. Make sure they assign it. Okay, so now we're going to talk about how do you protect trade secrets, right? Like I mentioned, the company is going to be the owner. You're not really worried about, in this case, assignment back to the company of trade secrets. You're going to have your trade secrets. Maybe it's an algorithm, maybe it's a formula, maybe it's a material composition, a mixture of ingredients, something like that, right? And you want to protect this as a trade secret. Look, we don't want to file for patents, either because we think it's not eligible for patent protection, or we just think it's so valuable as a secret. We want to keep it as a secret for 100 years. We don't want this ever to expire. We're going to keep it as a trade secret. Well, to protect it, I talked about those reasonable measures, right? There was the case with the company not having window film, tinting on their windows, right? You need to have something in your employment agreement about the protection of confidential information. And so the question is, how do you define it? And this is an example. It's a pretty simple way to do it. So you want to give the company kind of carte blanche to define things as trade secrets. So one is just anything you say is confidential, it's a trade secret. So if you designate it as such, the agreement should say, okay, that constitutes a trade secret. And then part B, maybe you forget to designate something, but you later want to say, hey, oops, we missed something. We still want to claim it as a trade secret though. You have the second clause, which says, look, if someone would reasonably know it's a trade secret, then it should be treated as such. And then you give a list of examples. And you can tailor this, to your specific business. The first one is more sort of like scientific things, formulas, computer programs, software, test results. The second thing is more about like business things. So it might be, customer lists, might be profit margins, contact information. That's the kind of information that typically gets left out. So tech companies are usually really good about protecting their tech IP. It's easy to say, hey, look, we're working on this AI and this way of training, the neural net. We want to protect that formula, the algorithm for training that neural net, how to add nodes and whatever. Right? People protect that. What they forget a lot of times is sort of on the marketing side, right? Your contact list, your profit margins, those sort of things can be protected as well. And you may forget to identify that as a trade secret. So this is sort of a catch-all that will sweep up some of that business stuff that you may forget to protect as confidential. So again, costs, profits, marketing, forecasts, budgets, all that kind of stuff can be protected as a trade secret. So put something like this in your employment agreement. And then here are a few exceptions. Typically, you want to give a few carve outs just to make it fair. And you want a court to see that, look, you really are delineating between what is reasonably a trade secret and what is not. So if you tried to have something that says, oh, everything's a trade secret, well, you're not doing a good job at distinguishing between what really can be protected by a trade secret and what can't be. And so you have carve outs. If it was known by the employee without any obligation to keep it confidential, if somehow it becomes publicly known without a breach, that shouldn't be a trade secret. If it was independently developed by someone else, still not a trade secret, right? So again, give these carve outs. And that'll make it look like the court that you're doing kind of the reasonable thing here. And so you actually have a better chance of protecting what is a trade secret. You don't want to go into court and say, yeah, this thing that this third party independently developed without any breach is actually a trade secret. I mean, it's not, it can't be, right? If it's independently developed by someone in the public without any breach, without stealing your information, then it's no longer a trade secret. So have these reasonable carve outs. Okay, some more provisions you want to include in your contract to protect trade secrets. Some of these agreements vary, but I like to say you have to keep it in strict confidence. I think that's the best way to protect it. So there are basically varying levels. Some will say, protect it with the same level of care you would other secrets of a like kind. I actually just like to go and say, no, if this is valuable to your company, it should be held in strict confidence. So don't give any wiggle room on these kind of disclosures. Second point here is have your employees stipulate to an injunction. So if you have an employee breach one of these terms, you want them to agree that the court can award an injunction against them. So this is, the scenario in which, say you're running Coke and you have an ex-employee and he wants to disclose something to Pepsi, right? You want to have the employee agree, hey, look, if you violate our terms of confidentiality, that no damages award can really compensate, no monetary award can really compensate you for that breach. It's very hard to put a number on how valuable that was to your company, right? So you want to be able to get an injunction from the court. The court says, no, look, you have to destroy whatever papers you have. We'll put an order in place. You have to stop talking to this competitor, right? You want a court to be able to come in and put that injunction in place, right? Because there are strict penalties if they breach an injunction from the court. So the point here is that that's really your only good remedy in these breach of confidentiality situations. Money damages are hard to prove and they're not likely to adequately compensate you. So you need what we would call specific performance or an injunction. The court comes in and tells that ex-employee what they can and cannot do with the information that they have. And then the third one, this is just sort of a note to look back at if you have an employment agreement in place, you want to waive a bond requirement. In a lot of states, they will require you, if you want an injunction against employee, to put up a bond, in case you're wrong. So, hey, I have to put a $100,000 bond with the court if I want to get this injunction. But you might not have access to that capital. So this just waive the bond requirement. So the idea behind bonds is that if you were wrong, say you seek an injunction against an ex-employee, and turns out, well, he didn't steal a trade secret. It wasn't actually a trade secret, right? It was public information or somehow he independently created it. The bond, they would go to compensate that ex-employee for a wrongly issued injunction. So you want to waive this requirement so you don't have to put that capital up. It doesn't risk you if you're wrong about seeking the injunction. So just look for that if that's in there. Okay, so the last slide here that I've got is about trademark provisions. Like I said, your company is going to own the trademark. As soon as you start using a mark in commerce, you start selling a product with a mark, you're going to have some rights. They're going to be state-based rights. So if I develop a widget, I start selling it here in California, under the brand Dustin's Widgets, I'm going to have some state-based rights. I'm going to have protection in California. But of course, you want to try to federally register it so you get protection across the United States. That's all going to be owned by me as the company. But there are things that you can do that can jeopardize the validity of your trademark. And so this is a few things to work out for. These are not assignment provisions. You're not requiring your employees to assign any trademark rights back to the company, but it's things if you license your mark out to someone else or allow a third party to use your mark in any way, right? So you might be a software company and you want, some clothing company to put your mark on their clothing goods to advertise, right? Or you want to somehow, market and brand your company as, but you're really not in the industry of making, clothing goods, right? So you might license your mark out to someone else in an unrelated field. And when you do that, you have to be very careful that you keep control over the quality of the goods that are branded with the mark and control over their usage of your trademark. So those are the two big things: control over the trademark and control over the quality of goods and services. So if you license it out, you say, hey, yes, you can do it. Here's the approved manner. You can use our mark, but only in connection with goods X, Y, and Z, right? So limited approval, obligate them to use the trademark, the TM symbol. You don't know, TM is when you don't have a federal registration. You say TM, so you have a trademark. Like I said, you have some rights just by using a mark in commerce. You're going to have rights. They're going to be state-based, but you're going to have some rights. Once you get a federal registration, you use the circle R. Right? You want to obligate anyone you're licensing to use these marks. You also want to obligate them to require pre-approval. So, hey, if you want to make any design, I'm going to license you. You can use my trademark in connection with, some apparel. That's fine. If you want to do any major changes to these marketing materials, require pre-approval. And then I also like to put in there, hey, let's disclaim that they don't own anything in the trademark, right? So there can be some confusion sometimes, and particularly if you haven't federally registered your trademark. Say you're using brand ABC and you just, hey, look, we're starting out, we're young, we don't have a federal registration. Maybe we'll get to it later. But you know what, we want to, and we produce software. We want to license it to this really cool, clothing company. They want to brand some of their stuff like ABC software, right? Okay, that's cool. So we'll do that. We'll license it. You want to be clear that they're not confused that they have rights in ABC, right? So they're going to say, look, we've been using ABC. You don't have a federal registration. So we thought we could go ahead and we could file for the registration. I've seen it happen in my practice, and it's a big mess to unravel because there's confusion. If you don't have a federal registration and they've been using that mark, they think they might have some rights to it. So include something in your contract that says, look, you're disclaiming any ownership right or interest you think you might have in this mark that we're licensing to you. So that's really important because if, what would happen is at the trademark office isn't going to know about any of this license stuff. They're just going to say, okay, so ABC software wants to file for registration, nobody else has, then we should grant it, right? And that will happen. They will just grant that registration. You then have to go back and try to cancel someone else's registration that shouldn't have been granted to them in the first place. So that's a real big mess you don't want to get into. The easiest thing to do here is just include provisions, making it clear that they know they don't own this mark, even though you haven't federally registered it yet. And then the second point is, we call this a naked license. So if you license your trademark and don't control the quality of the goods and services associated with that mark, you can lose your trademark rights. So you have to have control. Even if you're licensing it to someone else, you have to maintain control over the quality of the goods and services they produce and they stamp with your mark. So things that you can do, you can say, hey, I want a first article inspection, meaning the first product run you do, I get a right to inspect those products and make sure they meet our quality standards, right? And then a right to reject non-conforming goods. So this is critically important. critically important. If you're allowing a third party to use your trademark, you have to maintain these controls over quality. There are cases even when a parent company has licensed their mark to a subsidiary, right? You get these big international global companies, parent company, a bunch of subsidiaries. The parent company will typically license out their trademarks for one of their subsidiaries, right? Parent company might hold all the IP rights and they license out to the subsidiaries. Well, even that parent, even when it's a parent subsidiary relationship, the parent has to maintain the adequate controls over their subsidiary. They have to have these rights in their contracts, and parent companies have lost rights even in their own trademarks that were licensed to their subsidiaries. So be very careful here when you're dealing with third parties. And that is all I have.
Thank you. That was amazing. I mean, honestly, that was a very thorough coverage of questions that I hear very often from founders at Founders at the Garage. I just have a random question. It's about trademarks. I remember there, I mean, this is like way back when, you know, there was that, I think it was a Calvin and Hobbes character that had made its way into the decal world and on t-shirts. And I mean, it's pretty crude. He was just like peeing on various things, right? And it could be like company logos or whatever. And I'm assuming that as it grew and became more popular, there was probably some money to be had there. Would that be like a violation of these kind of trademarks? Because I'm assuming that this, whoever designed that was getting licensing it's to use all of the different logos that you know that they used for that product.
Yeah, no, that's interesting. That's an interesting example. So you know, the ultimate question in trademarks is whether consumers would be confused, right? So would they be confused as to the source? You know, when you get into these things that are like attacking a brand, it's not going to look confusing, right? So it's if you're disparaging, we call it fair use a lot in IP, right? So you have fair use to attack another brand, you know, but only if you're taking like the court wants to know that you're taking like the minimal amount required, right, to sort of criticize the source. And there's actually a distinction between whether you're being, you know, critical of the source, or, you know, whether you're doing a parody, right? So if you're attacking the brand from which you're borrowing their material, that's generally okay. If you're borrowing the source material from a company to sort of make a more general statement, attacking something about society, that's less permissive, right? So if you wanted to say use the Apple logo to criticize Apple, maybe it's their business practices, something about their, you know, their foreign workforce, whatever, right? Then that's more likely to be okay. I'm not saying they wouldn't fight you, they'd probably fight you, but you're more likely to be allowed to get away with that because you're criticizing the source and you sort of need to use their logo to identify who you're criticizing. If you're using the Apple logo to make a statement about, say, capitalism in general, you're making a broader societal statement, those are less likely to be permissive. So
because you're essentially borrowing their brand to make your case. So
exactly.
So then that leads me to kind of like a more startup specific question, which is, you know, for instance, in a pitch deck, oftentimes startups will end their pitch deck with, you know, their partners and people that they're associated with, right? And a lot of times they do that in order to kind of add like weight and validity to what they've been able to accomplish so far. Is it reasonable for them to be able to do that because they are essentially using the brand, like the well-established brands of their supporters and partners in the deck to make a case for themselves? Is the idea or expectation that they should be clearing that before they do that? Because I see it all the time, right? It's kind of like the Wild West, like people are just constantly updating their decks, adding people, adding logos.
You know, that you need to be careful. Right? The first thing that came to mind, I don't know if anyone here is following like the Theranos trial. Are you familiar with it, right?
I'm familiar. I'm not following the trial.
So one of like the most damning pieces of evidence was that on their reports, she was using logos from other companies without their authorization, right? No, and so that was a really difficult piece. Right now, that's of course that's a case of like pretty extreme fraud. And it's only going to be in those cases where it's really going to bite you, but it's always good if you can, especially if you're using, say you have an advisor that just happens to work at a big company. You have an advisor and he happens to work at Microsoft. Look, you can say, Joe Smith, Microsoft researcher. That's okay because that's identifying where he works. You start slapping the Microsoft logo on more things, you're going to run into more problems. So be careful there, because you may be implying approval, affiliation, association with a company where there is none.
Right.
But if you're just saying, hey, so-and-so works at this company, that's fine. That's a statement of fact and it's not going to mislead people. But yeah, it's funny that the Theranos thing jumped out at me because that was testimony a week or two ago. And yeah, she was borrowing, I don't remember if it was Merck or one of these big pharmaceutical companies that she was borrowing their logos and putting them on her reports. Yeah.
Incredible.
Yeah.
Okay, we have a question in the group.
Yeah, a quick question.
Lauren, I'm sorry, Tom. I just muted you because I was going to Lauren. Sorry, Tom. Are you there?
Yeah, are you going to Lauren? You can go to Lauren.
No, you can go. Go for it.
Well, two quick questions on if technology is not hidden from the public.
Yeah.
So in one case, let's say we have filed a patent and the utility patent is currently under review for a certain hardware design. And this hardware design is sitting in an open area within a building. And within this building, there's like 4 different companies that each have a separate little space in this manufacturing warehouse.
Yeah.
Because a patent's already been filed on this hardware design and apparatus, if we leave it sitting out without it being like covered by walls or cloth, is that okay?
Yeah, less concern there, right? Because you've already disclosed everything in a patent application, right? That's sort of the quid pro quo, right? You can get patent rights in exchange for full disclosure of your invention. Yeah, less concerned there. The only potential thing is if there's anything in that device that's not disclosed in the patent application, right? So that maybe you disclose all the hardware, but you didn't disclose, I don't know, the software or something, right? There could be something you're keeping, some algorithm in the software that you're keeping secret. Just be careful there. So again, that's why I always tell people, like, make sure you're clear on what you are keeping as a trade secret and what you're gonna protect with a patent, right? And so, yeah.
Okay. And what if we have some special secret software and algorithms sitting on a small computer or a Raspberry Pi connected to a flight vehicle, and we haven't filed patents on the software yet, and the little computer is sitting out in the open, but obviously people can't see the software on there. That doesn't like invalidate the secrecy of the algorithms or something?
Yeah, so that's an interesting question. So a couple things there, right? So if you are going to ultimately file for a patent application, right, there's a requirement that it not be publicly disclosed, right? In the US, you can publicly disclose it for up to 1 year before filing a patent application, right? So you can sell a product, you can disclose it publicly. And so the question always becomes identifying when that first public disclosure occurred, right? And then filing a patent application within that 1 year window. It's not a clear bright line rule when a public disclosure occurs, right? So there are things even we call like secret sales have been held to be public. So like say that like there was a case with a drug company and they had developed a drug and then they sold it, the future rights to it, to another company, and then they continued market research on it. No one else knew about it except this other drug company. That was held to be a public disclosure. And so that's what we call a secret sale in the art. So you have to be very careful because courts are sort of loath to say, yeah, you can get any benefit of a public disclosure and still file a patent application. But the good thing though is you get this 1 year grace period. Most foreign countries you don't get any grace period at all. In the US, you at least get that 1 year grace period.
And if it's software that exists and it's sitting on a computer and that computer is sitting out in the public, it's not like a public disclosure of the software because you can't see it. It's like hidden in the chip.
Agreed. Yeah, that's fair. Yeah.
Killer. Thank you so much.
Yeah, sure.
One more question. It's pretty simple, Dustin. Where can startups who probably can't afford legal services or lawyers to write up contracts for them, where can they go to kind of maybe get some boilerplate independent or employee contracts to protect their IP? Are there places? Are templates good enough? Is this like a space where you should just really have a lawyer help you out? Or is it something that maybe you can find online or through?
Yeah, it's tough. I mean, I guess I would say talk with other startups and see if they, can share some resources. Or if you can, come up, if you find a template online and sort of go through it and massage it, and then maybe have an attorney save some time and just have them review it. I mean, yeah, 'cause I've reviewed things that I can tell when they come from a public source like that. And they're usually either inconsistent or there are just pieces missing. And it doesn't make a lot of sense, unfortunately, right? So you do want to get those things cleaned up. I mean, I'm honestly working on one this week with, it was a licensing deal, and the company that wanted to do the license deal said, "Oh, we've been doing this for years. Here's our template." And I was like, "Well, you're missing pieces and there are terms here that aren't defined." I'm like, and they said, "Well, we've been doing it for years." I'm like, "Yeah, but you still got to button those things up." So if you can come up with a template, it does save time. If you have sort of a structure of your own, even if you can just list out, hey, here are the elements of the contract that we want, that can save a lot of time. And then try to look for those, if you can structure it and say, hey, we want to do a licensing deal, we want this royalty, we want this term, we want these protections, that's going to help, right? Sort of define the scope. Maybe you can build something around that and then just have an attorney just do a once over review at the end. It is tough though. I mean, it's unfortunate legal services are expensive, but it's always way more expensive to correct something later.
Sure.
Right. And so, even if you can afford, just an hour or two for an attorney to say, okay, look, it's not perfect, but you're in the ballpark. That can save you a lot of headache down the road.
Great. That's great advice.
Can I ask a quick question?
Yeah, please.
So Dustin, I have a software that's targeting financial advisors, and they can use that to create documents.
Okay.
I wanted to see one additional market was going to be attorneys for us. So I was hoping that if I can reach out to you and kind of share with you what we're doing and get your thoughts on how you do your work of these documents, that would be awesome feedback for me to build what we're building, eventually for attorneys.
Sure. Yeah. Happy to do it. Yeah.
Thank you.
Yeah, I'll just mention right now, Anand is one of our newest founders at the Garage. And so he's like still getting used to all of our really great resources. So actually, for the teams at the Garage, a lot of our speakers, including, thank you, Dustin, agree to do some free office hours for the Garage team. So yeah, you'll be able to contact him directly and hopefully set up some time as soon as you're both available to talk.
Thank you.
Yeah. I mean, I'll just, because we're at time and I want to respect the fact that you probably have other things that you have to go to, Dustin. I just wanted to once again thank you. It's so invaluable, these opportunities for our teams to connect with lawyers. You just mentioned earlier, it's expensive and it's not always feasible for them to ask even simple questions. And so I much appreciated. I hope have more opportunities to work with you in the new year, 2022. We'll have new teams. And so thank you so much for your time. Really appreciate it.
Well, great. I was happy to do it. Yeah. Thanks to everyone who attended.
Yeah. Maybe one day in person again. Who knows?
I know. I look forward to it. Yeah.
Right? Over some greasy pizza in the conference room like last.
Yes. That's right. Yeah.
All right. Well, have a good Wednesday, and we'll see you guys all in the new year with new events and new experts coming in and helping us out.
Okay. All right. Bye, everyone. Thank you. Bye.
Thank you. Yeah, just the one quick question. So if we want to make appointment with you for, office hour or private session, how should we make it?
That's a great question. I'll send an email out to the teams at the Garage in the weekly, my weekly digest out on Monday, Stark.
Okay, sounds great. Yeah, because
I'll also put his contact in our Slack channel.
Sure, thank you so much. Yeah, because we're about to file our trademark application, so just trying to find someone who can just help us with that.
Sure. Okay.
Yeah, Stark is who I had mentioned earlier to you, Dustin, when we were talking.
Okay. Yeah. That's great. We'll connect, Stark. Yeah.
Definitely.
Sure, yeah. Thank you so much.
Bye, everyone.
Bye.